Thank you. It's a pleasure to be here. It's a pleasure to be here. I usually start talks with a story, and since I'm an attorney, I know a lot of the stories, and since I won't offend myself, I'll tell you an attorney joke. It turns out there were three travelers. There was an attorney, an accountant, and a rabbi. And they were traveling in Eastern Oregon, and those of you who traveled in Eastern Oregon know that some of the parts of the state are pretty sparsely populated. And it was about 11 at night, and they were dog tired, and they were looking for a place to stay, and they couldn't find any place to stay. And they were getting low on gas. And they happened to notice off in the distance there was a light on at a farmhouse. And so they pulled up to the farmhouse and knocked at the door and asked the farmer there if they could stay. And the farmer said, well, I've got space for you to stay here, but only room for two in the house. One of you has to stay in the barn. And there's a cow and a pig in the barn. So the accountant, being the bravest of the group, said, I'll go out to the barn. And about a half an hour later, there was this knock on the door. And it was the accountant, and he was weeping and crying and just in tears. And he said, you know, I just can't stay out in the barn. I'm allergic to the cow. I didn't realize that, but I'm allergic to cows, so I've got to come inside. So the rabbi goes out to the barn, and about a half an hour later, there's this other knock on the door. And it's a rabbi, and he said, you know, I thought I could do this, but my religion just prohibits me from being that close to a pig, and there's a pig in the barn. So the attorney says, you wimps, I'll go out to the barn. So the attorney goes out to the barn, and it wasn't more than 20 seconds later, there was this knock on the door. It was the cow and the pig. So I open that way because if you're leaving, I'll assume that you're allergic to cows and pigs. Go ahead and hit the first screen. I'll move this over here. Okay, wouldn't be an attorney without some caveats, and we're going to cover some basics of copyrights this morning, and it's really basic. And so what you need to realize, if you have a fact situation, bring it to your own attorney to go over it with your attorney. Also, I mentioned a website at the bottom. The Copyright Office is very helpful with providing all sorts of information in terms of how to register a copyright, the basics of copyright law. This will be online too afterwards, along with the slideshow, so you can pick it up that way as well. Because I'm going to go through, I don't believe in reading the slides that are on the screen, so you can read as fast as I can talk. You can just do a Google search for copyrights, look for the Copyright Office. You'll find that website, and again, it just has tremendously valuable information in terms of how to go about protecting your own copyrights. So I would encourage you to check that out. Okay, who here is the proud owner of a federal copyright? Raise your hand. Okay, one. All right, I know a few of you know the answer to this question, okay? Anybody, oh, two, okay. Anybody written a letter in the past 20 years? Or an email in the past 5 years? Okay. You're all proud owners of federal copyrights. Okay, you all own copyrights. It's as simple as that. You own copyrights. All it requires is for the work to be original, which means you didn't copy the work. Okay, you created it. You write a letter to Aunt whoever. You've created those words on that page. As long as you haven't copied those words, it's original. It's a work of authorship. You wrote it. You created it. That's all that's required there. Fixed in tangible form. It has to be fixed. It has to be written down or keyed into a computer. It has to be fixed in some form. And on work of authorship, minimal creativity is all that is required. Minimal creativity, not a whole lot. Doesn't have to be a Michener type work. Your letter will do. Next slide. Okay, this is an example, just to let you know some basics of copyrights. This happens to be something that I wrote, and it's promoting a Thanksgiving Day dinner that's going to be held at the Elsie Stir Center here in Beaverton. We're going to serve about 400 people that really need help. And I was in charge of rounding up volunteers, and we needed 74 volunteers. They were all rounded up in about 10 days. People want to help. When people ask me why do I do things like this, Well, I guess one of the comments I could say is that somebody asked Mother Teresa at one time, and I've been told this, they asked her, said, "You must have a heart for the poor." And her comment was, "No, Jesus has a heart for the poor. I have a heart for Jesus. I follow Jesus." And so that's why I do things like put a meal together like this for the homeless and for those who need help. Next slide. Gray letter rules on copyrights. Gray letter rules. Okay? Not everything is copyrighted, and attorneys don't speak in black and white typically. That's why I say gray letter rules. Some things are not copyrightable, and so you can look at this list. Short phrases. When does a short phrase become a poem? Doesn't take a whole lot to go from a short phrase to a poem, but a slogan is not copyrightable, for example. Common information. The white page listings in the phone book, not copyrightable. It's common information. There is a bill pending or they're introducing a bill to protect databases, but right now they aren't. Facts aren't copyrightable. Ideas, processes, methods, you go for patent protection for those sorts of things, not copyrights. And the last one is just another example. Scenes of fair. If you see someone walking the plank in a pirate movie, okay, that's an idea. It's something that's common in that genre of movies. It's not copyrightable. It doesn't take much, but it takes a little bit. Basic rights. There's a bunch of copyrights in the copyright law, and I'm going to mention just a couple of them here, but they're like a bundle of sticks. They're like a bundle of sticks. Each stick can be passed out individually to however you want to divide them out. For example, the right of reproduction, that's to make copies, the right to make copies of the work. So I write my letter to my aunt. I have the right as a copyright owner to make copies of that letter. My aunt doesn't have that right. She doesn't have the copyright. I have that right. Derivative works, that's modifications. Distribution, the right to pass out copies of the work. And there are other rights as well. Go ahead and go to the next slide. What about sharing of music online? Anybody hear anything about that? Grandpa is busted. Okay. I'm not going to debate the merits of that till after we get done with the talk. Okay, then I'll be happy to talk to anyone that wants to talk more about file sharing online. I'm going to just sort of explain how it is, and then we can deal with it. Okay, I have to deal with it myself. Basically, I mentioned that bundle of rights, the sticks. Okay, one of the rights is the right to reproduce the work. When you download something into your computer, you are reproducing that work. That's making a copy of that work. If you burn a CD from your computer, you are reproducing that work. You are making a copy of that work. Okay, that was one of the rights that was reserved to the copyright owner. If it's an authorized copy, like Napster, $1 per download now, that's different. That's an authorized copy. You are licensed and have permission to do that within the scope of the license. The distribution right, if you share unauthorized music files, you are distributing those files to someone else, and that violates the right of distribution. Okay, it's pretty clear cut actually under the copyright law. Grandpa is busted. The answer is, unfortunately, Grandpa is busted. There's one story, it's a horrible story. A grandfather happened to own the computer where his grandson or granddaughters were downloading and sharing music files. The grandfather, who was 70 years old or so, didn't have a clue that that was going on, and yet got the subpoena from the record industry. And the way the law is set up, there's a lot of liability, vicarious liability, if you allow some infringement to go on in a position where you have control. For example, restaurants, if they have a live band come in and play, they're under control. They control those premises, and if that band is not licensed and performs copyrighted music, the restaurant is on the hook for that. Okay? And there are great cases on that, and maybe it's only interesting to attorneys, but stories where the restaurant said, I want you, band, to be here and only play uncopyrighted stuff. I want Gregorian chants in my bar. And the answer is, if the band plays copyrighted stuff, the restaurant owner is on the hook. Go ahead. Okay, here's another example. It's the same invitation, except that we've got in Spanish, so it's translated. It turns out that the target audience we're going for that dinner has a large Hispanic population. I don't know if you're aware of this, but for example, William Walker School, which is an elementary school right here in the Beaverton area, there are 500 kids at that school roughly. 250 of those kids are on assisted meal programs, and for many of those, that's the only meal they get during the day. They get lunch and breakfast. So one of the reasons we interspersed this, now I violated my, well, let's go on. Okay, great shot of a banana, all right? There's a reason for having the banana in this slide. And the reason for that is if you go down a grocery aisle, and let's assume it's a store that doesn't encourage you to sample, and you take an apple or a banana off the shelf and you eat it, that's theft, okay? Unless you pay for that apple or banana as you're leaving the store, okay? Under the copyright law, there are certain nibbles or free bites that are allowed, okay? This is the nibble principle right here, the nibble principle. Okay. Oh, that's a great prop. Our video camera guy is eating a banana as I'm speaking. So now you have it, it's called positive reinforcement, right? We have it on the screen and live. All right. Okay, go ahead and go to the next one. So the nibble principle is this. Basically, the copyright law sets up those bundle of rights, those sticks that I talked about, okay? Those are all set up. Sounds like the copyright owners have lots of rights, which they do. And then you have another section of the copyright law, which I call the left hand here, that chips away at those rights. Basically, there are lots of exceptions. Churches can perform music during religious services, things like that. And the biggest one you may have heard about is, next slide, fair use. Okay? Fair use is the right to use things for certain, under certain conditions. All right? And it's not very clear. It's another one of these gray letter attorney laws, okay, or interpretations. The purpose and the character of the use. Is it for nonprofit reasons? Okay? Is it nonprofit? The nature of the copyrighted work. Well, take the purpose and character of the use. Downloading, you probably have you do have an implied license to download and read what people have put online for your own personal use. That's the purpose and character of the use. The nature of the work, certain types of works, there's less copying than others. Fictional works like fictional books or works of fine art like paintings, you can do less copying. Realistic works, you can do more copying. Scientific works, a lot of scientific treatises are built one on top of another where you're taking quotes and segments of a previous work and building on that. So that's another factor. Third factor, how much have you taken and how important is the part that you've taken? If you've taken one picture out of a book, that it happens to be a key picture in the book, even though it's a 1,000-page book, that's an important part of that book, and you may not be under the fair use guidelines. And the fourth factor is what's the impact on the market, and that's the biggest factor. How much are you taking away from the copyright owner by doing what you're doing? Okay, next slide. Whoa! How'd that get in there? Was that a sucker punch? Was that planned? Oh, who knows? Who knows? Well, now that it's here, let's use it a little bit, huh? This is what you'd call a useful article, and one of the things that's tucked into the copyright law is if you have useful articles, like a chair. Here's a chair. In this country, you can't copyright a chair like this. You can copyright things that are separately identifiable, that can be lifted. So if there was some scroll work on the back of the chair, because I could take that and put it on a calendar or put it on a poster on the wall, I could use that. That would be copyrightable, but the chair itself would not. So like this flag, this wonderful flag, the flag itself, that's a copyrighted design. It's a copyrighted design. Also trademark protected and very ferocious. But it's a useful article because it's on a flag, it's on a stand, and so the stuff that's not separately identifiable, like the stand that holds the flag, that's not copyrightable even though the flag is. Go ahead. So basically, let's go to the next one. What does it mean? You ask yourself, do you have a useful article? Is the work separately identifiable? And I've already explained how it applies to the flag. And then you ask, are you British? The reason you ask if you're British is because the laws vary from country to country. In England, you can protect a washing machine. You can copyright a washing machine design, even though it's a useful article in this country. So again, it's one of those things, just a red flag. Lots of issues that are out there. Next flag. Now I'm going to use this to illustrate probably the one piece of information that I hope you take away from this. Well, actually, I hope you take away more than one thing, but one of the things I hope you take away from this is a faith community that I'm involved in called Soul Burst. And we meet at a coffee shop, and it's designed to introduce people to the Christian faith. And I'm really spending a lot of time on that, and it's interesting how my own intellectual property background plays into this. I'm able to get trademark protection underway for Soul Burst, get the domain name, work on the logo, get the copyright squared away. But with respect to the logo, this is the issue that I'm going to hammer home a little bit here. Let's assume that I paid the graphic artist $200 to prepare that logo, the flames, okay? And that look of that logo. Is it copyrighted? Answer, probably yes. Okay, minimal creativity. It originated with the graphic designer. It's fixed in tangible form. All right? Who owns the copyright? I paid him $200 to do that. The artist. Okay, the question is, the work made for art? You guys are really clued in. This is great. And the answer is right. It is the artist that owns the copyrights, even though I paid the artist $200 for this. I didn't, but let's assume that I did for purposes of discussion. This comes up all the time with companies that we represent. They've hired an ad agency to put together an ad campaign. They pay the ad agency $5,000, $10,000, whatever. Okay? And the contract is, you'll give me this ad campaign and here's the $5,000. Nothing is said about copyrights. The ad agency is fired. They go on to a new ad agency comes on board, and the new ad agency says, well, let's use some of this old stuff that the other ad agency did. Or maybe the owner says, I really like this stuff, let's keep using it. That's a problem. That's copyright infringement. You had a deal that gave you probably an implied license to use it in your ad campaign, contemplated at the time that you actually paid the money, but not for other uses. So, for example, with this logo, even though let's assume I paid for it and it's supposed to appear on publications and so forth, if I all of a sudden want to put it on T-shirts, I've now exceeded any implied license that I had, and I would be a copyright infringer by doing that. All right? Go ahead and go to the next slide. You asked the question about work made for hire. Before January 1, 1978, the law said if I paid someone for the work, I owned the copyrights. January 1, 1978, it flipped 180 degrees. Now the presumption is that the author owns the copyright. So the graphic designer owns that copyright in that logo, and we'll get to how you get around that in a second. Work made for hire, it's got to be an employee who is an agent under the laws of agency. Okay, it's got to be an employee working within the scope of his or her employment. Or it can be, there's 9 categories of works where you have an agreement in writing. Many courts say in advance that says it's a work made for hire. So if you have one of those 9 categories, you have the agreement, then it's work made for hire. Hardly anybody ever does that, so you can just scratch that second one off. That one doesn't count. So if it's not an employee within the scope of their employment, if it's an independent contractor, and you don't transfer the copyrights, you lose. You don't own them. Next slide. Has to be in writing. Okay, it has to be in writing. Run into this a lot with software programming. Companies starting out, they hire Fred, an independent programmer, to write some code. Fred writes the code. Fred goes off to the Bahamas. You don't know where Fred is. Company now gets some venture capitalists interested in the company. The venture capitalists say, do you own the copyrights? And they say, well, I paid Fred $500. Do you own the copyrights? I paid Fred $500. Do you own the copyrights? Well, let me see if I can find Fred in the Bahamas. So it's not that easy to reconstruct copyright ownerships after the fact. So take that with you because it's an easy pitfall for lots of people. Duration of copyrights. we really don't have to worry about it for new works. The Sonny Bono Copyright Extension Act, or Steamboat Willie Preservation Act as I call it, extended the copyrights for a long, long, long time. If I write a letter to my aunt, the copyright in that letter will last for my life plus 70 years. Okay, barring genetic cloning, I won't be around to see the end of my copyright term. For corporations or works made for hire, it's 95 years from first publication or 120 years from first creation, whichever expires first. So it's a long, long, long time. Yeah?
So if it lasts that long, are copyrights something that you leave to your heirs or something like that?
Yes, copyright rights can be left to their heirs. I was involved in a case involving Hemingway's book, The Sun Also Rises. And that was a situation where the copyrights were very valuable and it was very important to the heirs. Next slide. Infringement, basically, to prove infringement, you have to have a registration. If you're a U.S.-based author, you have to prove ownership, you have to prove access, and you have to prove substantial similarity. Access just means reasonable possibility of access in most jurisdictions. So if I have an article that's been published in 100,000 newspapers, the assumption is if somebody else comes out with an identical article, they've copied me and it's copyright infringement. If they can prove they independently created it, they lived on the moon and didn't see my article, and people believe that, it wouldn't be copyright infringement, because copyrights require copying to infringe. Okay, next slide. Remedies, lots of damages. Here's where the file sharing becomes very, very interesting from a defendant standpoint. It's a question of how quickly can we settle, how much do I have to pay? If you read through that slide, for willful infringement can go up to $150,000 per infringement, okay? And plus attorney fees are possibly as well. Even for innocent infringement, your grandpa, down to possibly $200 per infringement, probably no attorney fees. But if somebody has 1,000 shared music files on their computer, $200 times 1,000 is big bucks, okay? And so there's a lot of incentive to settle those cases. I don't, don't want to spend a lot of time on this. It's just the point that it's important to realize that copyrights can be costly if you happen to even inadvertently take the copyrights. Yes.
I know you introduced it with how a copyright is made, but what about videotaping something?
Okay, what about videotaping? Same rules. Same rules. We are co-authors of this venture here. Richard is videotaping me as I'm presenting it. I'm the author of the presentation. He is the author of the videotape. We may have a joint work. We have some joint ownership issues here. I can't reproduce the videotape. If it's a joint work, I could, and then I'd have to pay him a share of whatever I made from it. I mean, it's such a valuable tape, right? But videotaping, the rules are the same. It's fixed in tangible form. Okay, he's videotaping it. Is it original? You can judge whether it's original enough or not. And then that's basically it.
Okay.
Okay? Next slide. Equal time. I have ducks that are friends as well. Okay, and the last slide.
How embarrassing.
and the last slide, this is it. Go ahead. Thank you for your patience. I'm open to questions. Yes.
I'm getting ready to get a logo made. Should I write up a little agreement that says that I'm going to, I forget your name.
Okay, the question is, if I'm having a logo, or for that matter any other work prepared by someone else, what should I do? And my recommendation, and you can check with your own attorney on this, my recommendation is that yes, you do an agreement with the individual that's doing a logo. You do transfer the copyrights worldwide to you and the right of reproduction, and you have some consideration for that transfer, which can be, if you do it up front, it can be whatever you're paying them for the logo. I found that there are a lot of starving artists out there, so a lot of starving graphic designers. If you cut the deal up front, the copyrights kind of follow with the deal. If you go after the fact, well, now these copyrights are valuable, the price is somehow different. Other questions? Yeah.
You can, you said you can use some of copyrighted materials for educational purposes, non-commercial purposes?
Okay, the specific question is it has to do with fair use. You know, how much can you take? What can you use? If it's educational purposes, you have more latitude to take information, but there are still restrictions on what you can take. In fact, there's some guidelines that I don't have memorized here, but there's some guidelines for educators in terms of how much information they can take, how many copies they can make, and you're within those guidelines. Most publishers say it's okay, but there is more leeway if you're in an educational environment.
What about like sharing a Beaver logo, for example, at a presentation? Is that
Sharing a Beaver logo on a presentation. I'm taking the position that this is fair use, it's educational. I'm not being paid for this, so it's not for profit. And besides that, it's great PR. Yes.
What's the rule on quotations? Say if somebody's talking and you want to quote them in an article or you want to put it in a little gift book or...
Okay, the question is quotations. If it's a short slogan like "just do it," okay, that's not going to be copyrightable because it's too short. It may be a trademark, maybe some other issues involved, but it wouldn't be copyrightable. And so if it's short enough, you don't have to worry about copyrights. You may have something else that you have to consider. But basically, it's the fair use. Remember, one of the factors was how much have you taken and how important is the part that you've taken. If your quote is the entire speech, even though it was only like a 10-line speech, okay, that's the entire work. And then the question is how important, and the other factor is what's the purpose. If you're going to put it on a greeting card, that's a commercial use. You have more of a problem there than if you're doing it for nonprofit and putting it in your own letter to your aunt. Okay? Not a very satisfying answer, but it's a great attorney's answer. It depends.
One more on copyright versus patent. And then you get to the ambivalent stage where something is more hardware-wise than it is software-wise in the technical world, like firmware. So where's the transition point? I noticed you mentioned in British there, they said you could copyright a washing machine, but that's a hardware issue.
Okay, basically, copyrights extend throughout all the gamut of software. Whether it's firmware, whether it's machine-readable language, whether it's source code, the copyrights will cover all of that if it is original and sufficiently creative and it's minimal creativity. Okay, so copyrights are there just like any other copyrights. All right. From a patent standpoint, you can patent computer-implemented inventions. You can patent computer media with code that's on the media. You can patent methods that are implemented using computer code. So there's lots of patent opportunities in the software arena. Basically, for patent protection, it has to be new under the patent law, and there are a lot of requirements for is it new enough, and it has to be unobvious to one of ordinary skill in the art. But patent protection is widely available for software-related inventions.
Thanks.
Yeah.
Let's say I wrote a book and I sent it into some publishers to get it published, and they don't like it, but they kind of thought it's a neat idea, and they copied kind of, they have a totally different story, but like the same theme. Can I say they stole my work?
Can you say that? You can say anything you want to say. But the answer to your question, the question is, okay, I've sent in a book to a publisher, and then they haven't taken my book, but they've taken a lot of ideas okay. It really gets into the fair use aspect and whether they've taken copyrightable stuff. You can take ideas, okay, you can take scenes of fair. Those things are not copyrighted, so you can take those and use those in your own work without violating someone's copyrights. You can't take what they call expression, which is a little bit more than ideas, and it really gets down to, has the expression been taken? In a lot of cases on books, for example, that same issue, has the expression been taken or just the ideas? Okay, so it again, it depends. Unsatisfactory answer, but it depends on what they took. What you sent in was copyrighted. If you sent in a book, that's copyrighted if it's original with you. And then it's a question, what did they do with it? Did they take copyrightable stuff? Did they take enough of it to be an infringement? Because I mentioned on infringement, if the infringing work has to be substantially similar to the original work. And that gets into how similar it is. You heard of the story Wind Done Gone? Haven't heard that story? It's a play on Gone with the Wind. And they are actually involved in litigation over that now. Who knows how it's going to finally come out? But that's the same issue. There it happened to be a published book, and the issue is how much did they take? Did Wind Done Gone infringe the copyrights in Gone with the Wind?
And would a parody be an infringement?
Parody is, under fair use, parody is one of the, if you point to the purpose and character of the use, if you have a parody, you have more room to argue that I'm in the fair use category. But it's pretty limited. Some of the cases say you can only take as much as you can to conjure up the original. Okay? Why don't we just take 2 more questions? Actually, go ahead, and then I'll take this one next.
Is there a book you would recommend for somebody who needs some basic information to refer to on copyrights that might put it in layman's terms instead of legal jargon?
Okay.
Yeah.
The question is, do I have a book that would explain copyrights in layman's terms? And I guess that, I use too much legalese here today, I guess. But no, I'm kidding you. No, the answer is the information on the Copyright Office website. It's really very well written, and most works, like for books, it's Form TX, and it's like filling out a 1040 easy tax form, or maybe a form, maybe not the 1040, maybe not the easy form, but there's a Form TX for books. For works of visual arts, it's Form VA, and so you can go to the Copyright Office website, and they have circulars that are very well written that talk about the different types of works and things you can consider. And so I would suggest that you go there, look at that, and then if you need follow-up information, then check it out with your attorney. Okay.
I was of the understanding that if I produce something, I could just put copyrighted and my company name and the year on it, and that copyrights it. But what I'm hearing you say is I have to actually file a form and go through some steps.
That's a great question, and the answer is you're doing perfectly well. All right. In this country, since March 1, 1989, you don't have to have a copyright notice on the works to have copyright protection. So that's one of the problems with the internet. Just assume that it's copyrighted. If you take something off the internet, great photo, assume that somebody owns a copyright in that, even though there's no copyright notice. You may be an innocent infringer, but since March 1, 89, you don't need a copyright notice. If you have the copyright notice, then people can have trouble arguing that they're innocent infringers. And so it's a good idea to put the copyright notice on, and you can put the copyright notice on without doing anything. You don't have to register anything to put the notice on. To get the enhanced damages, the statutory damages and attorney fees, you have to register within certain time limits. And if you're a US-based company, before you bring the copyright action, you have to have registered the copyright. Okay, so it's sort of the more you do, the more protection you have. Frankly, a lot of companies use a rule of thumb, and they'll put a copyright notice on lots of stuff, and they only register their more important things. Okay? Okay, 2 questions from a parent of teenagers who may or may not be involved in downloading music.
He's not right now.
He's not right now, okay.
Taking all this in me to keep that from happening.
Okay, so the question is, what about Kazaa and the old Napster? And the basic answer to that is that it's all illegal. I mean, it really is all illegal. You can download, there are songs that are available for download where artists have put them online on a free basis, and they encourage you to share because they're struggling artists or whatever, and they want people they want the music to become more popular. So you can look at the source of the information. Some of those songs are authorized. Okay. In terms of now, you have Apple and the legal Napster, about $1 or so per song download. And that's the direction the music industry has been forced to go. So instead of buying a CD with 12 numbers, you want one of them, and you spend $12, or it used to be $15. Now it's 12. Would drop the prices. You can buy that one song for $1. So that's what I would encourage people to do. In terms of enforcement, the reality is it's like the little Dutch boy pushing fingers in the dike, and it's like a sieve. There's water gushing out all over these places, and so what the music industry is doing is trying to make an example. They're going after people that are sharing major amounts of files right now. Technically, they could go after somebody that has one download. Practical matter, I would never expect them to do that. And when they get a bad PR case like the grandpa or the person in the public works projects back in New York, they settle very quickly because they want to try and maintain as much of an image as they have. So that's sort of it in a nutshell. Okay, thank you so much. It's been my pleasure.
Thank you.